All right, so we are going to talk about Chapter 8 and the right to counsel. So the first case we have is Gideon versus Wainwright. Gideon versus Wainwright is probably over the years has had a huge impact on the government in two ways. One, it places upon the government the responsibility of providing counsel for individuals who cannot afford an attorney on all felony cases. So it made a huge shift from only capital cases to all felonies. Um, that's the first thing. And then the second impact it had in Gideon is that by requiring the county to support or provide attorneys for individuals in all felony cases who cannot afford an attorney, it's a huge financial cost for the government and in turn for you and I, because you and I are the ones that pay the bill for an appointed attorney. So in Gideon, he is convicted for felony, breaking into a pool hall, I believe. And his argument was he was entitled to a lawyer, and because he was being incarcerated in prison, and so his liberties were being removed or taken away, and that was enough to require the government to provide an attorney for him. And I would say that because the laws today are so complicated in the criminal arena, as well in the civil, that an individual in most felony cases would be at a disadvantage if they were required to defend themselves. So I think that based on the complexity of the law today, that this court made a good decision. I think where the courts have fallen short is their ability to determine who is actually an indigent defendant, one who cannot afford a lawyer. So I've seen firsthand many times when an individual had the funding to pay for their own attorney, but instead was allowed to use public funds for a lawyer, which means you and I are having to pay that bill. And it also slows down the court process, because if I'm not paying for services, then I'm generally going to ask for more services. It's when you have to pay for those services that you become more responsible and prudent in your decision making. And so less cases are being foolishly challenged in the court if you have to pay for your own attorney. All right. So Hinton versus Alabama is a case where the defendant has multiple charges of robbery and murder. And during the investigation, physical evidence is found, and it has to do with bullet casings and a couple of guns. And so the issue is, stepping back, you have physical evidence that should be tested not only by government, but a competent defense attorney is going to want their own expert opinion on the physical evidence. And the question is, one of the guns that were confiscated, did this shell casing come from one of those guns? And so it's clear on appeal that there were at least three experts that would have said that it was inconclusive. We don't know. In other words, we don't know whether or not this particular casing came from a particular gun. At trial, the prosecutor had an expert. I believe he had two experts that said that in fact, the casing had come from a particular gun. The defense counsel in this case made a couple of errors. The first one was that he did not educate himself on what was allowed as far as funding. So what happens in the real world is there are times when an individual will hire a lawyer and they don't have all of the funds necessary to maintain the attorney. So sometimes the court will choose, it's cheaper to give the attorney money for instance, in this case, for expert testimony, rather than for the state to foot the entire bill of hiring a lawyer and the whole process. So In this case, the defendant asked for $1,000, or the court was willing to give him $1,000 and said, "Hey, if you need more money, come back and ask the court, petition the court." And it's not a difficult thing to do as a defense attorney. You generate a motion saying, this is my expert. This is what I wished to hire. This is the reason I'm going to hire them. This is who they are, and this is what they charge. So you attach a proposed bill, and so the court can see that. You attach in your motion, you include why you want the expert, why it's relevant, why it's important in order to defend your client, and then the court makes a decision. Well, every state has budget limitations on certain things, and so in this case, for this in Alabama, apparently there was a $5,000 limit on an expert, this type of expert. Well, the defense attorney never took the time to do the research to determine what, if any, was the dollar amount that the state was willing to give the attorney for an expert. They took the $1,000. They assumed that's all that he could use. He hired an expert that truly was not an expert in ballistics. And so at trial, his witness failed. The prosecutor was able to show that this person was incompetent in their ability to testify on the particular issue in front of the court. And so on appeal, the defendant says, "Hey, this is an ineffective assistance of counsel because the attorney didn't do their job, didn't do the legal research, didn't ask for the correct amount of money, and didn't bring in the experts that they should have brought in to defend me." And they were able to show, look, there were experts out there that would have been able to testify that these case shallings, it was inconclusive whether or not this evidence came from a particular gun. And so the court looks at two things. Remember, court looks at two things. The first thing it looks at is whether there was an error, and whether and then secondly, whether or not there's a likelihood that the outcome could have been different. And so on this case, the jury, important part of their determination of guilt was the fact that someone had testified that the evidence came from a particular gun. And so, yes, it was easy for the court to conclude that the outcome could have been different had dueling experts come in there, had expert come in and said, "Yeah, we don't know whether this evidence comes from a particular gun." And so this attorney is found to be incompetent, or at least they found him to be found that there was ineffective assistance of counsel by the way he handled himself in his decision to, one, not do the research, and number two, not to request the funding from the court and put on an appropriate expert to defend his client. All right, Commonwealth versus Bland. And in Commonwealth versus Bland, you have an individual that was fled to Florida who had committed a murder in Philadelphia. And prior to him going back to Philadelphia, he's arrested, and then he sends a letter to law enforcement saying, "Hey, I'm invoking my Sixth Amendment rights." Now, keep in mind, when he's in Florida, he has not been arraigned, and he's only being charged with it. So he's not entitled. Remember, an attorney, you're entitled to a lawyer at any critical stage. And he has not even been brought back to Philadelphia. So that standard of critical stage has not been even approached just yet. And so when he is brought back, he is given the same, the officers approach him like they would anybody else. They brought him in, sat him in a room, provided Miranda, and questioned him where he incriminated himself. So he's saying that what he's saying is that, hey, I already invoked my right to an attorney, and when I was in Florida, and what the prosecutor argued and what the court determined was that you were too early. You don't have your right to ask for counsel. Only occurs at critical stages, and that's only after the government initiates they use the term only after the government initiates an adversarial judicial proceedings. In other words, your the the right doesn't even kick in until they start formal proceedings. So he was basically way too early. So when you're looking to answer the question, especially the first question, when does the Sixth Amendment right to counsel attach in criminal cases? Look for terminology such as the government's. I'm sorry. Let me start over. That a critical stage is only after the government initiates adversarial judicial proceedings. So take a look in the court's opinion and look for that language for this case. So in other words, your right to counsel only kicks in after they start the process, and they had not started the process when they issued the warrant. That's not when the process starts. Formal proceedings would be when they set him up for arraignment. So at the time of arraignment, that's when formal proceedings would start. That's when his right to an attorney would kick in. And then if he could not afford a lawyer, one would be appointed to him. All right. So the last case you have is the state versus Quattlebaum. And in Quattlebaum, the defendant and his attorney had a confidential conversation at the police station. And this prosecutor did what a prosecutor should never do, and that is listen into a conversation. So I will tell you that in the real world, first of all, if you're in a police station and you're a defense attorney talking to your client, you have every right to a private hearing. I'm sorry, a private conversation. So a prosecutor listening in is a direct violation. So that attorney, that prosecutor should have walked out and put himself or herself in a place where they couldn't listen to the conversation. Or number two, if they were in a place where they could not avoid it and they're listening to the conversation, they should have let the other party know that they couldn't avoid listening, or definitely had told the defense attorney that, hey, this is what happened. I got stuck. I couldn't get out. I'm listening to your conversation. I couldn't communicate to you, but I want you to know this is what's out there. And you lay it all on the table. I will tell you, in the real world, there were so many times in the courtroom when things are happening. You've got multiple attorneys in the room, multiple defense attorneys. You may have one or two prosecutors. And it was very common for me to be in a courtroom and a defendant and their attorney would be having a conversation that I could clearly hear. And the rules are really simple. That if I'm in a place and I have to be there because if the court gets on the record, they expect me to be sitting in my chair and ready to go. So I am stuck in a chair and I have a defendant yelling at their attorney or an attorney and a defendant talking loud and I can hear them. The rule is, under no circumstances do I mention to anybody what that conversation was about, and I would never use that information against the attorney or the client. And then if it's a situation where I feel that that information that I'm listening to is relevant to a hearing I'm going to have, then I'm going to sit down with the defense attorney and say, hey, I heard the conversation. So what do you want to do? But you let that attorney know right up front what happened, and then you're able to deal with it that way. Most defense attorneys understand that. They know if they're talking to their client in a busy courtroom that other people are going to overhear it. And you use good discretion. You try not to use that information, and never intentionally. So in this case, though, this prosecutor was totally out of line. Clearly a violation, an ethical violation, and that attorney should have been punished for it. Okay. Again, I don't need a response to this video. Simply do the briefs. That's the only assignment that's required for you to turn in. All right. Be safe, and we'll move on to Chapter 9.